either questions that were submitted ahead of time, and I have one, actually two, one just came in, or questions that you have live, or if something's unclear, it's kind of your opportunity to ask questions of a professional. All right, so sorry, that something's coming in. So if you do have any questions, feel free to put it in the Q&A and I'll make sure to try to answer them. And I was like, start with positive focus. Something positive is my family is all healthy, COVID free, and my kids are back to playing soccer. So my daughter had soccer practice last night, and we're hammering out the details on my son's team. This year is going to 11v11, and I coach my son in soccer, so it's fun. And used to coach my daughter in soccer, but now she has a real coach, so lucky for her. But that's my positive focus. All right. With that, let's go ahead and get started. So this was a continuation follow-up question from last week. We spent a lot of time last week, and actually last couple of weeks, talking about I-bonds. Just because I-bonds are right now offering a guaranteed 9.6%, I think, rate of return due to inflation. And nowhere else can you see a guaranteed 9+ rate of return. Now, it's not always going to be like that. They're in like 6 month increments, easy for me to say. But as of right now, they're scheduled to be over 9% rate of return over the next year. And there's limitations on them, and we went over the limitations multiple times. Basically, you're maxed out at $10,000 per person. If you have a trust, you could do another $10,000 in the trust. There's limitations on who you can name as beneficiaries. One question I had last week was, the question was STIP. I think they meant TIPS, TIPS, where you can buy basically I-bonds or as part of your market portfolio, but there's no guarantees with those. Plus you have additional expenses. So if possible, going directly to, here's another question coming in. Going directly to Treasury Direct is the best way to do it. And then the question, a follow-up question someone had that I wanted to clarify is just the tax implications on this. So the interesting thing about I-bonds is they're taxed at income tax rates, not capital gains. So any growth is not taxed at capital gains, it's taxed at income tax rates. So if, let's say you have 10,000, and then you cash it in at 15,000, you're going to have $5,000 of income that you're going to show. And you can either show the income annually. What most people do is they just show the income at the end. And then the question is, what happens if someone passes away? If they haven't showed the income, then that's going to be income tax potentially to the beneficiary. So they're a little screwy in how they're taxed, but at the end of the day, it's just because typically people don't have a ton of I-bonds, it's not something that really moves the needle from a tax perspective. And again, really the only reason I-bonds are so hot right now is because inflation rates are so hot. If you look at I-bonds historically, it's been like 1-2% rate of return. So it hasn't been knocking out of the park. But for right now, for kind of short-term money, if you have some cash set aside, I-bonds are a great way to look. And you just go to treasurydirect.gov to get that going. All right. Our second question that came in, and I have one other question that just came in, so I'll make sure to get that. And if you do have additional questions, feel free to put it in the Q&A. And I know my handwriting is horrible, so I'll repeat it. Who should be the beneficiary of my life insurance? Should it be a spouse or a trust? So the situation is we have family. So that's the situation. It was a husband and a wife. They have adult children. And I know in this situation, we have a revocable living trust. So typically a revocable living trust doesn't actually own your assets. You would still own like your home, your IRAs, cash, life insurance. Typically with a revocable living trust, you would remain the owner of these things, but then upon death, they would go to the trust. And then the trust would then provide for, I drew this badly, provide for the kids. Now, the one thing that's a little bit different is IRA money, qualified funds. Qualified funds, we always name spouse first, then the trust. And yes, we name the trust the beneficiary of the IRAs, not the kids, because the kids are the beneficiaries of the trust. And a lot of times we build in some certain protections for anyone inheriting through the trust. So that's for qualified funds. And there's a tax reason. They can do a spousal rollover, which is one of the follow-up questions, is getting to the RMD proposals and whatnot. So with qualified funds, we almost always name spouse first, then trust. Okay. Now for life insurance and non-qualified funds, like if it's a joint account, like that's fine, joint and then trust. But life insurance, if it's only on one person, we would just name the trust as the beneficiary. Okay, because the spouse is the beneficiary, but the situation would be, let's say we have a husband and wife, they're in a car accident, husband passes away, wife is incapacitated. Now that life insurance proceed is going outright to the wife who's incapacitated. Now the kids would have to step up and create a conservatorship to manage that money. But if we name the proceeds of the life insurance to the trust, then the trust could provide for the surviving spouse, but now one of the kids could be the successor trustee. So it's not something that's happens very often, but by us naming the trust as a primary beneficiary of life insurance, it can protect against some potentially screwy situations. And we've seen this, doing this for 16 years. So life insurance, or really any other non-qualified accounts, you should name the trust as the beneficiary. Retirement accounts like 401ks, 403b, typically spouse, then trust. But at the end of the day, the most important thing is we want just everything flowing into the trust. This is our rule book. This is what avoids probate. This is what builds in the protections for the beneficiaries. Okay. All right. All right, here's the last question. This was an old one. Let me get rid of that. All right, this last question that came in, and if you do have any more questions, please put it in. The latest on RMD proposal. For Roths. To be honest, I was on vacation for a week and I saw some news come across on this, but I'm a little fuzzy. But keep in mind, it's still, we've just seen proposals on this. So, and sometimes I have proposal fatigue where they talk about making changes so much, like, and they've done this already, but let's just kind of talk about some of the details here. So first thing is we have two types of really qualified accounts. We have tax deferred, and tax deferred accounts are like IRAs, 401ks, 403bs, and then you have accounts that are tax-free. The big one here is the Roth, and you can have Roth 401ks, Roth IRAs. So again, these are what I call always taxed. Now there's certain exceptions, like if you're doing qualified charitable distributions or that type of thing. But the big thing is this is taxed at income tax rates. And most people think taxes are scheduled to go up. Tax-free is basically never taxed anymore because it's already taxed, so all the growth goes tax-free, okay? Now, what happened, and we've talked about this in the past, is, okay, what happened previously is that when you passed away and you left IRA money to the next generation, they used to be able to stretch out the taxes over their lifetime. We would call this the stretch IRA. And if you left the money to like grandkids, the RMDs would be so low, you're almost creating an annuity or pension for them. But what happened is that the Secure Act of 2020 is passed in 2019, got rid of the stretch IRA. And now it says all the taxes when your kids have to inherit the money have to be paid or taxed within 10 years. And there's confusion of, is it all taxed like evenly, 1/10 each year? Is it all taxed at the end? Do we have to take out RMDs? So basically the rule is now, if the person who passed away is over 72, you have to take out RMDs based on their lifespan. And then at most, all the taxes have to be paid within 10 years. So if you had a $100,000 IRA you inherited and the person's 75, you might be required to take out, and I'm making up the number, $5,000 a year for 10 years, but by the 10th year, all the money has to come out. And they're flip-flopping on that. Now, with the Roth, interesting thing is we still have the same 10 years. We still have the RMDs, but there's no tax. Okay, you just have to pull the money out of the Roth IRA, and all of it has to be out of the IRA within 10 years. Okay, but there's no tax on it. You just have to pull the money out and now put it into a qualified account or a trust account. Now, I've seen some proposals and talk, and again, I'm a little fuzzy on this. I'm just coming back from being out on a vacation. So nothing set in stone with this, but there's been some thoughts about changing that 10-year rule for the Roths, extending it, potentially getting rid of it. I think I may have seen something saying they're talking about extending it like 20 or 25 years, which would be good from an individual perspective. So that means you can just grow money longer in a tax-free environment. With the way the government's hurting for taxes, I don't see them really doing that. In fact, even with some of the earlier proposals, not that they were getting rid of the Roths, but they're starting to put limitations, even more limitations on who can contribute or convert over to a Roth. So in fact, I see them getting rid of some of the avenues we have to get money into the Roth. And we've seen that with some of the earlier proposals. So yeah, it'll be something we're keeping a watch on. I think right now taxes are the biggest risk and biggest opportunity. Understanding how you have pre-tax dollars versus tax-free. I was meeting with a family even today, and they had about 2 million pre-tax, or hypothetical family, and they had retired a couple of years ago. Now they're getting near the RMD, and we've been talking and working with them on an annual basis of moving money from the pre-tax account, getting it up to the 24% tax bracket. A, so the rest of their retirement is more tax advantageous. B, if taxes do go up, they're in a better spot. And then C, they have 2 children that are doing really well. And so the children have their own income. And now if they had to pay all the income tax on what they're inheriting from mom and dad over a period of 10 years, it'd really put them in a disadvantageous spot. So yeah, we're looking at these Roth conversions and the tax rules, not just for retirement planning, but also legacy planning and estate planning and what you're leaving to the next generation. So, and especially given the Tax Cuts and Jobs Act and the fact that we probably won't see a ton of changes until at least presidential election, we still have some time left to get money out of those pre-tax accounts and look at Roth conversions. With regards to what they'll do with the RMDs, that's something that's important. But as of right now, my understanding is still we just have the 10-year rule. I've seen some noise, but I can't codify exactly what that is. So, okay, that is all I have. Any more questions? All right, I'm the PA. Here's a question. I'm the PA for someone and have signed it. Does my signature accepting the POA need to be notarized? So the comment is that this person is serving as a power of attorney for that individual, and they have to sign something. And this is as of 2012 for the financial power of attorney. You need to sign accepting your role as financial power of attorney. Does it have to be notarized? To be honest, I'm blanking on this, but we have our financial power of attorney acceptance pages. We have them notarized. So I think we're doing that based off of the statute, if I remember correctly. So yeah, I would say the financial power of attorney acceptance page has to be notarized. The medical power of attorney does not have to be notarized. So they're passed through different statutes. The financial power of attorney is notarized. The acceptance, the medical power of attorney is not notarized. So, but yeah, to serve as a power of attorney, you need to accept that role. What if it is not? I did it in a lawyer's office. Just get it notarized. Have them reprint it and notarize it, or call us and we can draw. If we see the power of attorney, we can then get it notarized. And all you have to do is like walk to a bank, like banks have notaries. Okay. All right. And go. Thank you. Thank you. You're welcome. All right. Cool. All right. That's all I got this week. Make it a great week. Take care. Stay cool.